I always think of co-location as someplace where you already have an antenna and you're going to put another one on the same structure. But no, if you have an existing structure with no antennas and you're going to put something there, that's still co-location under this statute, and it would be exempt from local regulation unless they're going to, there are certain thresholds. If they're going to increase the height of the structure by more than 10%, or if they're going to increase the area of an equipment compound by more than 2,500 square feet, that's more floor area than's in my house, for example. So it's really a lot of things that are no longer subject to local regulation. I will skip the one on top, page 7. Well, just briefly, this is not something that planning and zoning boards do very much, but it has to do with when your road agent is doing, or highway department are doing road, culvert, and drainage work. What this basically does is that if the town or city gives advance notice to the affected landowners on either side of the culvert and gives them an opportunity to come in and complain if they want to, then the town becomes protected against tort lawsuits, even though it may still have to pay damages, but it's a very small time window. So anyway, then the very last thing I have on the new statutes is 3 new statutes from 2014, which of course the session isn't quite over yet. The second to last one there, you may know that when a highway is being discontinued, or a road is being discontinued to Class 6, the law has for several years required owners to be notified 14 days in advance of the town meeting action or legislative body action at which that discontinuance is going to happen. This extends that to a situation where there's an existing Class 6 highway and it's going to be totally discontinued. The landowners need to be notified of that as well. Then the very last one on page 7, a new 2014 statute which clarifies what a subsequent offense is. Now, under the primary land use enforcement statute 676-17, you have a civil penalty of $275 a day per day of violation, beginning on the day either of a conviction or on the day when the violator gets written notice that they are in violation. And then it says there's for subsequent offense, it's $550 a day. Well, but it never defined before now what subsequent offense meant. What it says now, however, is that if the landowner does not respond to the order to stop the violation, then anything beyond that constitutes a subsequent offense. So that is what I was going to say about new statutes. I'm now on to some court decisions, and the first couple have to do with standing. Standing means who has the authority to appeal, or who has the legal right to appeal a land use board decision. And the rule that we've lived under for many, many years has been called the Weeks Restaurant test under the Weeks Restaurant versus Dover, a 1979 decision. To determine whether a non-abutter has a sufficient direct, definite interest to confer standing, the trier of fact may consider factors such as the proximity of the challenging party's property. How close is it? Can they honestly say that they're going to be able to view this thing and it's going to affect their property value potentially? The type of change proposed, the immediacy of the injury claimed, the challenging party's participation in the administrative hearings. Those are the factors. So under this golf course investors one, it was a very strange appeal. It was a neighbors group. They apparently were close enough to claim proximity, but they hadn't participated in the planning board's proceedings at all. And furthermore, they didn't claim to be injured. They just thought that this project needed a special exception, and so they appealed the planning board decision to force the applicant to get a special exception, but the Supreme Court said that's not enough to confer standing. You aren't claiming to be injured at all, basically. The other case on the next page is the Hannaford brothers, which was decided this past year, where a supermarket that was 3.5 miles away from another supermarket that had just gotten a variance wanted to appeal the variance. And the Supreme Court said, well, they couldn't claim to be proximately located at all. I mean, they had no interest that was different from anybody else in town, except the fact that they were in competition with this other store. And the Supreme Court, following an existing rule from the Nautilus case, said that doesn't count as an injury. That competition is a risk of our free enterprise society and not considered a legal wrong. I had occasion recently to cite this case in Littleton because they had a guy who owned a campground about 2 miles up the road was complaining about the practice of Walmart of allowing campers to camp on the parking lot in Walmart. And it got to the zoning board of adjustment and they asked me for some advice, and I said, well, I don't see that they have standing. They're clearly in competition, but competition is not an injury under these cases. And so I think that allows me to raise the point that these cases govern not only standing before the court, but also standing in terms of who can appeal an administrative decision to the zoning board. I think the same rules apply. The Hanover brothers tried to claim, well, we should have standing because the board cited our case. In other words, talked about our property and the comparison between the two in its decision. So clearly we have an interest in this decision. The court disagreed. No standing. The 1808 case on top of page 10 is a 2011 decision which basically underlines the notion that zoning board decisions, special exceptions in particular, are specific to the project that got a special exception. And it can't really be varied from that. If they want to expand the project or they want to put in a different type of business or something like that, they need to go back to the board and get an amended special exception or variance, as the case may be. The owners in this case tried to claim, well, we're not expanding by very much. We're expanding so little that it would be, under the law of non-conforming uses, it would be considered a legal expansion of a non-conforming use. And the court said, so what? I mean, this is not a non-conforming use, it's a special exception. That rule just doesn't apply. So I think one lesson which boards need to learn from this case and others is, especially if you're granting something on the zoning board of adjustment, you usually don't have a lot of plans in front of you. You may have a napkin sketch in some cases. You really need to specify exactly what the scope is of what you're granting, because then only that way can somebody 20 years from now determine whether what the person is then doing is within the scope of what was originally granted. And there's been several cases where they weren't specific enough. The famous Bethlehem landfill case, where they had granted a variance years before, but nobody knew what the scope of what was granted. So it really needs to be very specific. I know I've sit on a zoning board, I have for the last 25 years almost, and we always have what we call standard condition number 1, which is the project shall be completed in substantial accordance with the plans and testimony on file, and any material change shall require further action of the board. The limited additions case, town of Hebron, you may know about, if you go over to Newfound Lake and you look up toward the northwest, there's a very steep hill. And this project would have carved a road right up the steep hill that would have been seen from all over the lake. The planning board disapproved it for these reasons, that it would have an adverse impact on the lake. The main argument that the developer used was, you should have granted our request to only have a preliminary decision and then waited until we'd gotten our state and federal approvals to make your final decision. And they argued that, and the reason they claimed that the board should have done that was that if they got their state and federal approvals, that raises, they claimed, a presumption that it was a good project and that there would be more reason for the local planning board to approve it. And our Supreme Court said, no, that's simply incorrect. There is no presumption that just because you get approval from a state agency or a federal agency, that you're more likely to get approval from the local agency. So the planning board was upheld in its refusal to grant a preliminary or tentative decision. They had instead simply given a final disapproval, and the court said that was okay. Several cases on variances. The Harborside case, there are two Harborside cases, but this one had to do with a variance. This was one of the first variance cases decided under the 2009 statutory standards for unnecessary hardship. And it's sort of unusual because the special conditions of the property were conditions that didn't even exist. The special conditions of the property were the bulk and the size of the proposed building, and for that reason a variance had been granted to the applicant, which was a hotel in Portsmouth, to erect signs that were larger than would otherwise be permitted. So this is pretty interesting. Harborside was the competing hotel, but this time they had standing because they were next door. They argued that this hotel could operate just fine without these huge signs, and the court said, well, but ever since Simplex, a variance has not required that you can't make a reasonable use of the property without the variance. That is no longer one of the standards for a variance. You don't have to prove that there's no reasonable use of the property without the variance. They also argued that smaller conforming signs would have been adequate. In other words, some lesser variance would have been adequate. The court rejected that too. The notion that the benefit must be one which can't be achieved by some feasible method other than a variance. That was a test under the old area variance test, which has now been superseded by the statutory definition of unnecessary hardship. The next one, the Brandt Development Company, stands for, the lesson for this stands for a very short and easily remembered principle. Namely, that if somebody was denied a variance prior to the Simplex case, they can now reapply for that same variance. The usual rule is, under Fisher versus the City of Dover, is that if you've been denied a variance, you can't reapply for the same variance. That's considered final. There has to be some material difference or material change of circumstances. But the court said that basically the decision in the Simplex case in 2001 constitutes a material change of circumstances for every variance that was denied prior to that, and so they get a second bite at the apple under the Simplex standards. The third one is also important, the Bartlett versus City of Manchester. If you're on a zoning board, this is very important. And the gist of it is that if somebody applies to your zoning board for a variance, you should always take a look at the issue of what they can do without a variance. What happened here was, it was a church, and they wanted to set up what they called a work-based self-help organization on church property. They applied for a variance. let's see, it was granted by the board, I think. The Superior Court, it was appealed by a neighbors group. The Superior Court found that that the court didn't have to decide whether the variance had been properly granted, because the Superior Court found that it was an accessory use. That this program that the church wanted to run was incidental to a church use, similar to other programs that churches run. The neighbors group said the Superior Court shouldn't have decided that, because when the church applied for a variance, they waived that issue. The Supreme Court disagreed with that and said every variance case involves the issue of what they could do, whether they need a variance or not, and what could they do without a variance. So again, I think the lesson is, if you're on a zoning board, you get a variance request, it is open to you as part of your decision to say, this doesn't need a variance. Why might you say that? Well, you might decide that the zoning administrator interpreted the ordinance wrong. The zoning administrator interpreted as requiring a variance, and maybe you decide, based on the language, that that's not how it should be interpreted. Second possibility is you decide that what they want to do is part of a non-conforming use, a minimum sort of change in a non-conforming use. Or thirdly, as in this case, that it counted as a valid accessory use to a permitted use. So if you get a variance request, don't say, well, you know, the issue of whether you need a variance is not before us today, because it is. Here's the other Harborside case, and it has to do with the 5-year exemption. Remember, I talked about the 5-year exemption. It used to be a 4-year exemption. And the gist of it is that if you reach certain thresholds, your project is protected against changes in regulations. This case talks about what can be protected against changes in regulations if you change your plans during the 5-year period. And the hotel here had an approved site plan, and they wanted to change it. They wanted to change a substantial amount of what had been marked as retail space into a conference center, as I recall. And the Supreme Court said that's a substantial change, and that is not protected by the 5-year exemption. You have to go back and as if you were not protected at all. Now, you know, the court admitted that there might be some minor changes that were so insignificant that that they were simply incidental, and they wouldn't make you lose your rights under the 5-year statute. But any actual change of use like this would not be within that protection. The one on the top of page 15 has to do with timing of appeals. It seems like for the last 25 years there have been cases on how many days you have to appeal, and if the 30th day falls on a Saturday or Sunday, do you get until the following Monday, or if Monday is a holiday, do you get until Tuesday? And basically this case says the answer to those is yes. There is now a 2008 general statute in chapter 21 of the RSAs, which is a chapter that sort of governs the interpretation of terms throughout the RSAs. And it says basically any deadline that falls on a weekend or holiday, you don't have to comply with that deadline until the next business day. Hopefully that issue is put to rest. The one on the bottom of page 16, Property Portfolio Group versus Town of Derry, has to do with the planning board granting waivers from its regulations. You know, the legislature a few years ago added both to the site plan statute and to the subdivision statute the authority of a planning board to grant waivers. And it says that the reasons for the waivers have to be in writing. In this case, the neighbors complained that the waiver was invalid because the reasons weren't in writing. The minutes of the planning board's meetings reflected several comments by individual board members of why they thought the waiver should be granted. And the court ended up saying that's good enough. That the minutes record of individual comments did constitute a written statement of what the reasons were. Clearly, however, that is not what we would recommend going forward. The better and safer thing to do in terms of a planning board waiver is to have the reasons for the waiver as part of the decision that you actually vote on as a full board.
Croc TV.